Okay, welcome. This is our weekly edition of Facebook Live here at Joseph and Hall. I'm happy to reintroduce Zach New to you, one of our attorneys on the corporate and federal litigation side of the practice, and also currently the president of the Colorado chapter of the Federal Bar Association. And we also have a new face who just disappeared, probably trying to figure out his camera. And this is Ryland, who's a new member of our team. Will also be working with us on corporate side and federal litigation. So what we're going to do today is just give you first a couple of updates about things that are happening in the world of immigration law, but also in our office with regard to some of the litigation that we filed and are going to be filing this week. A couple of new cases that we're going to be filing this week. Then after that, it was like the voice of God all of a sudden.
Maybe that's mute Rylan while he gets the worked out.
After that, we will take your questions, and so feel free to ask us questions. We like to be stumped. Don't worry about trying to stump us in the chat box, and we'll go from there. So let's start with give us updates, Zach, on pending litigation. Anything happened this week with our pending litigation, and also what are we going to be filing this week?
Oh boy. So what has happened with our pending litigation this week? I mean, a lot of movement on our cases is the big news. We've got our K1s for Kinsley and Milligan are getting a lot of movement now. So, that's just terrific news. And more than anything, that's the biggest update on what's been happening with our current litigation. What we are going to be filing this week is a targeted K1 lawsuit on Brazil, which should be really any minute now. I think it's in the process of being filed as we speak, as well as one targeted at the Philippines. That should be tomorrow or over the weekend if we need to. Beyond that, let's see. I mean, I was prepared to filibuster about the new picks for USCIS.
Which we're going to talk about.
But
let me give you a couple of updates on Milligan. So Milligan, we have a joint status report due to the government today. I also had a call with the U.S. Attorney Joseph Carilli this week to give you an idea of where we are in the case. It is our position that even though on April 9th, the Department of State issued a blanket national interest exemption to all K1s and all immigrant visas, that does not moot out the lawsuit, because as we've seen in the past, one hand giveth and the other taketh away, right? I mean, the proclamation itself exists. It continues to exist, and all of you continue to be subject to it. The only difference is that the court has said we're going to grant you an exception to that proclamation. That exception could go away if things get haywire around the world with regard to COVID. It could also go away as they face a crisis in backlogs with family and employment-based cases. A CNN article came out last week that referenced the Kinsley case that we filed last week and said that 2.6 million cases are currently in the visa backlog. So thank goodness we filed this lawsuit for Kinsley and for Milligan. And thank goodness those of you who haven't been issued visas have a mandamus claim that's pending, because even if the judge agrees with the AUSA and says, okay, I think your injuries are moot as a result of the proclamation, it certainly doesn't moot out your mandamus claims for the fact that your cases are still sitting there and will continue to sit there. So you need to know that this week today we're submitting to the court a status report that basically says we're ready to go forward on the mandamus claims at this point. Court, we know that you've been holding them in abeyance to give the government the opportunity to do what they need to do and adjudicate these cases, and we appreciate that. The government's been doing a good job of that. But to the extent that the proclamation does anything, it certainly hasn't helped the plaintiffs that are still waiting for a visa interview. So we will go forward now with a briefing schedule on the mandamus claims, with the government's brief being due May 6th. Our response to that brief, if any, will be due 3 weeks later. And then the judge will then decide that motion to dismiss, because it's not going to be a motion for summary judgment that the government's going to submit. It's going to be a motion to dismiss, essentially arguing that the case should now be dismissed because it's moot, right? Because there's no longer a redressable injury because all the K-1s can now get their visas and travel. Our position is that's just not true. As long as we have hundreds of plaintiffs that are waiting for a visa, we will continue to fight the case, and it's definitely not moot. So that's the update on that. I do anticipate that the judge will probably schedule this for an argument, for some sort of hearing with regard to, you know, what our plan is and why we think that this case continues to be litigated. Good news on the Tate case, which is the O1 challenge to visa suspension of O1s. All plaintiffs in that case have now been adjudicated. They've all been granted their visas and have entered the country. So we'll be voluntarily dismissing that case as a 100% success this week. We also filed last week an individual case against the embassy in Cairo. Cairo is not subject to a proclamation. They can issue visas. They have always been able to issue visas. They just don't want to issue K-1s. And so we've got a bunch of plaintiffs together and filed an individual case against Cairo last week. As Zach indicated, we're filing another case this week against Brazil. And then next week, we'll be filing a case against Manila, as well as another case against Cairo with regard to immigrant visas. And speaking of Brazil, we have the person who's been working feverishly on the complaint, Jennifer Howard. It's got to be minutes away from ready. Is that correct?
Yes, I'm making the final edits for right now.
Any announcements about plaintiffs or anything you want to tell us about? Who's our lead plaintiff?
Oh, the lead, Avery Penn.
Tell us about
our lead. Avery is a disabled, retired U.S. Army veteran and colonel. 90% disabled, and they've had their interview rescheduled, I think, 7 times. So yeah. It's a pretty compelling case. Yeah.
So. All right. So that will be filed this week. Couple of other updates. Zach is working on a case with the American Immigration Lawyers Association that will challenge the methodology that the government uses to choose H-1Bs. Zach, talk to us about what we're doing in that case.
Right. So I feel like this is the only thing that I talk about anymore is H-1Bs. But anyways, how the H-1B lottery system works, I think we all kind of know from my previous rants about it. It's kind of a randomized selection. There's 85,000 visas available. 20,000 of those are for folks with master's degrees or higher. And it's a randomized selection. The statute requires it to be kind of a first in, first out type thing. And so what that kind of, I guess, on the ground turned into was pretty much just random selection. That's worked out fairly well. I mean, fairly well. There's, of course, a whole bunch of issues with it that we've previously touched on, but
a whole bunch of fraud, frankly.
A whole bunch of fraud. It's cost prohibitive when we do it without this, kind of $10 registration fee method. But anyways, under the Trump administration, USCIS decided that they wanted to change the way that this worked. Previously, they said, we can't really change this because the statute says there's a very specific way that these H-1Bs have to be selected. So if we want to do anything, besides like a randomized selection, we'll have to get Congress involved. But at the end of the Trump administration, they decided, to hell with that. We'll just change it however we want. And they decided, we'll prioritize those people who have the highest wage levels, the people who are, what they say are the best and the brightest, but are really just the people who are being paid the most. That is kind of, contrary to this statutory mandate of first in, first out, and is certainly not randomized selection. So the complaint's really just saying, first off, that's contrary to the statute. And then the second part of this is something that a lot of other lawsuits have brought up and won on. The previous acting secretary of Homeland Security was Chad Wolfe. He was, I guess, not really, he wasn't appointed. He wasn't, he just kind of fell into that position through a series of weird executive actions. And the method of actually becoming an acting secretary or an acting head of an agency is very specific. There's statutes that lay out the order of succession, they call it, for the leaders of these agencies. So Chad Wolfe was not supposed to be the acting secretary. There was no way that he was supposed to be the acting secretary. After he became acting secretary, he did a whole bunch of stuff. He made asylum regulations that were terrible. He made this H-1B rule that's terrible. And then, in an attempt to kind of fix all of this, after losing in court several times, decided, that first off he would be appointed, and then he would, go to a Senate confirmation, and before that, he decided to ratify all those actions, saying, everything that I did was fine and it is law now. That's contrary to statute as well. Somebody who's acting as the head of an administrative agency unlawfully cannot, their actions can't be ratified. Essentially, that's the law. So the big two claims in this lawsuit are, first off, you can't change the rule to be wage-based. That's just against statute. And secondly, the person who did this, they don't have the authority to make this rule in the first place.
Yeah.
So
how have the courts interpreted that in the past with the Chad Wolfe thing?
How have they interpreted it? I think there's 5 or 6 cases that have said, yeah, no, he is absolutely not able to do this stuff. He is absolutely not lawfully the acting secretary of Homeland Security. And in fact, what was it? It wasn't the Inspector General. Was it the Inspector General? Anyways, one of the kind of government oversight agencies put out a report on this and said as well that they—
I think it was the OIG, yeah.
Oh, so the Office of Inspector General put out a report saying, we are also in the executive branch. We're kind of an oversight agency, and yeah, no, he is not supposed to be the acting secretary. His response was, whatever, and he just kind of kept trucking along.
Yeah, so I think this case is really interesting because unlike other cases, there's not a lot of facts involved, right? I mean, it is what it is. You have this lottery. We think it's wrong. We're going to tell you why we think it's wrong, but there's not going to be any facts in dispute. So what our plan is to file the complaint and then immediately move to summary judgment, because there's nothing we really have to battle about. It is either lawful or not. And so we're hoping we'll get a really quick decision on this case, and well in advance of this rule going into effect. So stay tuned on that one. Okay. Any other updates on any of the litigation? I think there's some questions about the Go case. Go v. Blinken is our case where we are filing a mass mandamus on behalf of individuals who are trying to get DV 2021 visas. So this is only with regard to DV 2021 applicants. We are filing an amended complaint on the Go case. And so if you want to join the Go case, there are about 10 minutes to do so. To pay your retainer and fill out the forms and get it to us. Ryland is working on gathering the documents for that case. I promise you that I do not have Ryland in a prison in Guantanamo, even though it appears that way from the look. He's going to definitely be rated very low on Room Rater, because that room you need stuff on your walls, Ryland. And I know you can't respond to me because you have no volume.
I can't.
Oh, darn it. I was hoping you wouldn't be able to respond. But okay, respond.
Yes, I know. I definitely need to put up something. Anything really will work. And yeah, I've been doing some work on the Go case. Been going through all the affidavits that we've gotten, making sure that they're all signed, making sure they're all in the correct format so that we can submit them to the court as one massive evidentiary file. And we are still waiting on some individuals to send in signed versions of their affidavits. So I doubt if you're here right now, that's one of you. But if it is, please send it in, and we need a signature on it, preferably written and not typed, but we'll take anything at this point. So.
And what's the next step in the Go case? What are we doing next?
So I believe we're still contemplating whether or not we're going to file for summary judgment or a motion to, I'm not sure what the other option was.
Yeah, I mean, the difference between this case and like the wage case is that there's real harm here, right? I mean, these people have a few months to get their immigrant visas. And if if the consulates don't move, there's real irreparable harm. So this case will be filed next week with what's called a motion for preliminary injunction and or summary judgment. So we're asking the judge to either find that we've established success on the merits and irreparable harm and to just grant an immediate injunction, ordering them to immediately start putting immigrant DV cases at the top of the list, or summary judgment, just saying that, suspending immigrant visas with regard to DV applicants is pure unlawful. So keep in tune with us for that one. Watch us next week, and we'll have some updates on what's going on with the Go case.
Just I guess one quick update on that before we go. We got kind of a nice little, I guess, stroke of luck there. The case that's challenging the 2020 DV, debacle of not issuing diversity visas for 2020. We got the same judge, so he's already looked at this. He knows the issues. He's fully on board with all of this. And so it might be that we file this motion for summary judgment. He goes, oh yeah, I've already ruled on this, and we go from there.
Yeah, so Judge Mehta's decision in the Gomez case was interesting, because in that case he found that the plaintiffs could not establish irreparable harm to grant a preliminary injunction except for DV 2020 applicants, right? So there were about, I don't know how many plaintiffs were in the lawsuit, but he basically said, yeah, with regard to DV applicants who are on a race against the clock, I do think there's harm. So I'm going to grant the injunction with regard to them. But he did not grant the injunction with regard to the other plaintiffs in the case. So he's aware of DV 2020. He knows that the government didn't do what they were supposed to after he issued the order in the preliminary injunction. So he's going to be watching this case very closely, knowing that, September 30th is the deadline. And if the government doesn't move on this case, we're going to ask the judge to reserve all 55,000 visas into the next fiscal year, because that's the only way to redress the harm from simply not moving on these cases. So that's the plan. All right. Any other updates on federal court before we go on to other stuff? All right. What happened this week in immigration law? Anyone want to chime in on this? Who wants to start?
I could talk for an extended period of time about how we got a new USCIS director.
Perfect.
All right. So let me first take us back for a while ago into the Trump administration, or let's go even before that. So USCIS is the benefit granting part of the immigration system. They're supposed to be the good guys. They're the ones that you apply to get your green card for, and they're supposed to be the good guys. They are broken up into two sections. It's this kind of the benefit granting section, and then this section called fraud detection and national security, which I think is actually unlawful under the statute that created USCIS, but that's besides the point here. For a long time, their mission talked about how we're a nation of immigrants and how they would be serving customers. How they referred to people who would apply for benefits with them. But under the Trump administration, that all changed under the director, Francis Cisna. They took out customers. They took out the phrase "nation of immigrants" from their mission statement. There's been a massive increase in denial rates, in requests for evidence is being issued. Very much it started to turn to a enforcement agency rather than a benefit granting agency. I worked with a professor at the University of Colorado on a piece about this, where we talked about how this is mission drift. They're drifting away from their original mission into becoming this enforcement entity that they really weren't supposed to be. Now, though, we have a new USCIS director. Is Urjado? Is that how you pronounce it?
Yeah, Urjado. Yeah, and her husband, by the way, is an ALA member and a member of the American Immigration Lawyers Association. So.
Who sounds terrific. So she was working at DHS Watch previously, which is kind of an oversight on the Department of Homeland Security. She's a professor of law. She's an immigration attorney. She's just terrific in just every way that I can see right now. And so my hope now is that we're going to start to see a shift from this mission drift that we were seeing to a culture back to a benefit granting organization where USCIS will be more willing to work with attorneys. I mean, just as one example, we used to be able to directly contact the service centers and directly contact the field offices as attorneys. That got taken away during the Trump administration. So hopefully these channels of communication will be brought back. This kind of focus on finding fraud wherever it could possibly be will be taken away, and we'll start to see approval rates return to normal rather than this massively heightened denial and request for evidence rate that we were seeing, which really just drives up costs for everybody. And I mean, there's a lot of erroneous denials that turn into federal court cases. So anyways, very hopeful about that. Because it remains to be seen if the culture will shift, immediately or how long that'll take. But that's my update that I'm very happy about.
Awesome. Any other updates in the world of immigration from you, Jennifer or Ryland? Anything you can think of?
There's also a new director of CBP. I don't know as much about that.
Yeah, I don't know much about that either. The other one that I'm excited about is the over in the White House. I'm sorry, not in the White House. In the Homeland Security, Ali Mayorkas, who has always been very favorable and good on immigration issues, an immigrant himself, has hired a woman named Royce Murray from the American Immigration Council to be one of his policy directors. So the American Immigration Council is a think tank that really delves in deeply to immigration policy. And, Royce has been with them in their communications department for many, many years. So again, another hire that knows a lot about immigration policy and forward thinking and how to make the immigration system workable for our economy and for employers and families. So really good news. All right. Are we ready to go to some questions? Stump the experts?
Let's do it.
All right. Here we go. Let's go up to the top here. All right. This is a good question. I've been thinking about this myself. So as you've heard, Biden is doing stuff against Russia in reaction to the hacking of the election. And one of those things is, I read this morning, pulling diplomats out of Russia. What will happen then at their consulates, right? So I have heard anecdotally that Moscow is at 20% staffing at their consulates. So absolutely, this will definitely impact K-1s. It'll impact immigrant visas. It'll impact non-immigrant visas across the board. What do I recommend? I recommend that you try and get your case transferred. If your case is at the NVC and at the write to the NVC and to the Moscow embassy and ask, since things are delayed at the Moscow embassy, if you can have the case transferred to another consulate. In a public briefing, I can't remember what her title, but somebody from Department of State said absolutely that you are entitled to move cases from consulate to consulate. And we have that document. We can send you that document. That's what you should rely on with the NVC in Moscow and asking that your case be transferred, because their policy people say that it is a possibility. If they say no, then that's good evidence for us when we go back to the Mandamus, right? That you've done everything you can to try and move your case. It's not your fault that the government's not doing their job. So email the consulate, email NVC, CC both of them on each other so that you know that you're communicating, so that they don't blame each other for the problem. And then send any response that you get to us. Make sure you update the spreadsheet for Milligan plaintiffs that we have online, or send us the email that you get directly from the consulate. Same question here, expulsion of diplomats, unknown at this point. Okay, here we have a Kinsley K-1 plaintiff, not a Milligan K-1 plaintiff. Milligan is specific to K-1s. Kinsley is a challenge to the proclamations globally, saying, you can't suspend visa processing of any category. But this person is a Kinsley K-1 plaintiff in London, stuck at NVC, have emailed the embassy now. Embassy has acknowledged DOS. Yes. Okay. So here's what you need to do. So remember, you have to email both parties. So you have to email the NVC and the consulate in London at the same time and cross-reference each other so that they know, so that the NBC can't say, well, we're not sending it to London because of health concerns at the consulate, and London can't say we're not scheduling interviews because we don't have your case from the NBC. The bottom line here is that London is now under a direct order to prioritize K1 plaintiffs, right? That's what the April 8th memo from DOS says, is that now K1s are priority. The problem is that in an FAQ, I'm going to put the FAQ up in a couple minutes here, but the Department of State on their Facebook page listed an FAQ about visa backlogs, and one of the questions is, what if I'm a Milligan plaintiff? And what they say in that FAQ for the first time, which came out on the 10th, is that being a named plaintiff in Milligan or any other lawsuit does not give you priority for visa processing. The consulates are not required to put you up in front of other people. They're just supposed to process you in the normal pattern of processing, right? So this is the first time that they've publicly said we are not going to prioritize Milligan plaintiffs. Now, whether they're doing that, privately is another matter, because as we know, cases are moving in the named lawsuits. So my guess is that they don't want to publicly say, if you sue us, we'll put you at the top of the list, because then everybody will sue them. But privately, that's what they're doing. The good news for you is that you're in a mandamus suit. Not Kinsley, but Milligan is in a mandamus suit. So we still have that bullet that we can use to try and move the case. Kinsley was a different lawsuit because it was just a straight-on challenge to the proclamation itself. So now you get in the door, but in order to get that case moving, you're probably going to have to file an individual mandamus. That may be what you need to do if they don't move on Kinsley plaintiffs on their own. Okay, here's somebody just thanking us for all we're doing. Milligan round 2. We did have somebody interviewed out of Milligan from round 2 today and granted a visa. I think it's the first one we've seen from Manila in a very long time, but it was a round 2 plaintiff. Update on the meeting with the government lawyers on Tuesday. I've already talked about this. Basically, the update is we are moving forward with litigating the mandamus claim. We're pretty much conceding in a way that there's no injury any longer from the proclamation, but that injury could come back if the Department of State changes their mind. But what we're not conceding is that these cases are not unreasonably delayed. So we will be fully forward moving on the mandamus claims. The government briefing is to be resolved within the month of May. So May 6th, the government brief will be due. Ours will be due 3 weeks after that. How did the joint status report go today? Already talked about that. Mary and Gus, I hope this is okay, but I've named you in the lawsuit, in the status report by name. There are 2 plaintiffs from Montreal, you and one other, that I've named by name in the status report because you're round 1, and at this point you should be adjudicated. So I hope that's okay. If it's not, let me know. All right, Helen, good evening from England. Milligan round 3, still at NBC, emailing both without response. Any other suggestions? Can you join another suit? You cannot join another suit. The rules of civil procedure don't allow that. So unfortunately, that won't work. What I can tell you is, let me see if I can look up real quick on cases moving in London and tell you if there's been any cases that have recently moved out of London. Because we are seeing a lot of movement, round 1, round 2, and round 3. So I'll get back to you on that in a minute here. All right, another question. Email the London Embassy, NBC. London has just given us the same generic email, same thing. All you can do is keep emailing them at least once a week. And all that we can do is keep raising up and elevating your individual cases to the U.S. attorney and the judge. Now that we're moving forward on mandamus, the judge is going to have to look at each individual case and the delays. What is the injunction about in the Kinsley case, and what will it mean for us plaintiffs? So, okay, so what happens in federal cases is that they can last a very long time, right? And so we know that your case has already lasted a long time. That's not okay for you. How do we get interim relief? How do we get immediate relief? Zach, talk to us about how we do that.
So we would file there's really two names for it. We could file what's called a temporary restraining order or a motion for a preliminary injunction. The temporary restraining order kind of converts into a preliminary injunction. And that's where we show basically that there's immediate harm happening, that we're likely to succeed in this case, and that when you balance the equity, really it comes out in our favor. The judge will look at all of that, and in the case where we're successful, we'll order some sort of preliminary relief. So, like for example, in Milligan, where we said, hey, look, there's all these people who are not able to get their cases adjudicated. We really need some relief now while this case is ongoing. And the judge looked at that and said, yeah, you're right. There's this likelihood of success in the merits in this unlawful no visa policy. There's significant harms to the plaintiffs. On balance, the equities are kind of on our side. So I will order this preliminary injunction, put it in place, and say, government, you have to adjudicate cases, even if there is a preliminary, or even if there is a presidential proclamation in place. So that would be the first thing to do to kind of get like immediate short-term relief. The bad thing.
And if you win a preliminary injunction, do you win the case?
You do not. That's the bad part of the preliminary injunction, is that it is preliminary. It doesn't cover the entire case. It doesn't mean that you're done. It means that you have some sort of reprieve while you get to litigate the case in the meantime. Going back to Milligan, we filed that in September. Here we are in April. The case is still not resolved and not close to being resolved. If we didn't have this preliminary relief, then people would be waiting for a lot longer, and we wouldn't have had this movement that we've had for the folks in Milligan. So the next step would be to actually file to win the case, and that's the motion for a summary judgment. That's where we say, here are the facts. These are the ones that are not in dispute. Here's the ones that we are disputing. I mean, in most of these cases, there's not very many facts that are in dispute. And then we say, here's the law. Judge, make a decision based off of these facts and the law, who wins. That's where all of our legal expertise comes in, where we make all of the fun arguments about, actually what the law says and why we are correct in filing this lawsuit and why we should win. That can take a long time. Briefing schedules alone can take months. We could have, our first motion for summary judgment due in 30 days, and the government could have 30 days to respond to that, and then we could have another 3 weeks to respond to that. And then the judge really can make a decision whenever they want on the case. It takes a long time. Judges' caseloads are extremely high right now. There hasn't been new judgeships really put in place since I think the 50s. It's been so everybody's caseloads are really high, I guess, is the point there. And that means that motions for summary judgment, the actually end piece of the case, can take a super long time. That's why this kind of both sides of the case are important. The preliminary injunction is important to get the relief while everything's pending, and the summary judgment's important to actually win the case.
Mm-hmm. The way I like to think of a preliminary injunction is it's like going into halftime in a football game 4 touchdowns ahead, right? I mean, you still have the second half, right? And things can change in the second half, but it is hard to overcome 4 touchdowns, right? Because what a preliminary injunction says is there's a lot of harm here, and that harm outweighs the harm to the government. And I think you've established that you're going to win this lawsuit. There's a substantial likelihood you're going to win. So that's the 4 touchdowns, right? And it puts the government in a box where they're like, do I want a published decision on this issue that will be used as precedent for other cases? Or do I want to try and resolve this before we get this? So getting that preliminary injunction at the beginning sets the stage for how the negotiations will go for the rest of the case. So it is an important part of the case, and something that is very, very positive if it happens. Jennifer, any updates on the K1 Egypt lawsuit after we filed it a week ago?
So I think that there's, if I remember correctly, there's maybe 24 people who have actually been scheduled for interviews.
I don't know the exact number, but I would say about half of the plaintiffs have been scheduled for interview.
And then a few more have had their case moved from the NBC to the embassy. So right. Things are moving for people. And that's
Yeah. Why is this good news? Because the government hasn't even entered their appearance on this case. We haven't even communicated with the government about this case, right? And you went from no movement to half of the plaintiffs being scheduled. So obviously, I mean, it's definitely because of the lawsuit. But we will be able to move things even more quickly when we know who the government attorney is on the other side. Other news on K1, it was related to Milligan. We filed a notion relating the case to Milligan, and it was in fact related to Milligan. So we have a judge on the case who has already decided that he doesn't like delays at the consulates. So it's good stuff. We have good stuff on the Egypt case. Oh, good news, good update. Daughter-in-law is coming over on Saturday on the NIE from her K1 from Milligan round 2. So that's fantastic. Great news.
Have them send us wedding pictures, please.
Yeah, send us wedding pictures, post pics from the airport when you get here. We put those up on Twitter, and it helps give other plaintiffs hope who are still waiting. So
also, we really like to see them.
Yeah. All right. So are Milligan plaintiffs who don't have interviews likely to get an interview faster than non-plaintiffs because the judge knows? Yes. They're, as I said before, their public-facing information is that Milligan cases don't get priority. But think about the motivation for saying that. If they came out publicly and said, if you sue us, we'll put you at the front of the line, think about what would happen, right? So they're not going to say that. But what we know is that Milligan cases are moving, and they're moving at a pace that's faster than the general population. So being a named plaintiff does in fact help you. And here's the other piece of that is if you win the mandamus, which we're moving forward on now, you will have an order from a judge specifically ordering the consulate to adjudicate your case. So on all levels, now and in the future, it's definitely better to be a named plaintiff. Any news on whether Kinsley will become a mandamus? As mentioned before, Kinsley will not become a mandamus. We were clear about this in the FAQs because it's not just one class of person. We have DV applicants, employment-based applicants, non-immigrant visa applicants in several different categories, K1s, diversity visas. And so it's impossible to establish one category of delayed, unreasonable delay, or likelihood of success on the harm. It would be nearly impossible for a judge to go into every case and say, yes, universally, these are all unreasonably delayed. So from the beginning, this never was going to be a mandamus. We were really clear about that. Having won the issue that not won it, but having the Department of State basically backtrack on whether K1s qualify for NIEs is a huge step forward because now you can get in the door, right? And you can come without quarantine. But as far as getting the case moving, that's where you're still going to need a mandamus if Kinsley doesn't cause your case to move. It's our hope that being in Kinsley will cause your case to move because they want to moot it out just like every other lawsuit. So it's our hope that that will happen, but mandamus was not part of the claims. All right, which embassies are moving on the K1s? It's easier for me to tell you which ones are not moving on K1s, and that's essentially the ones we're suing, right? So we are Moscow, problematic. London was problematic, then it got good, and now it's problematic again. Manila, problematic. Rio, severely problematic. Any ones that I'm missing? Montreal, problematic. Amsterdam was problematic. Now they've scheduled a bunch of round 3 plaintiffs, so they're moving. Stockholm is moving again. So we're starting to see movement on consulates that were having a problem in the past. Any others that you can think of? Cairo, yeah, for sure. Will we say that London hasn't responded to emails? No, we're not really getting into that much detail, granular detail in the status report. The status report is really just kind of like, where are we with the case right now? So what we've done is we've broken it down into round 1, round 2, and round 3. We've talked about the number of plaintiffs we had at the beginning and the number of plaintiffs we have left. And of the plaintiffs we have left, we've broken it down by consulate and the number of cases that are stuck at the consulate. And if there's consulates that simply have not scheduled, we're highlighting those and pointing those out. But we're not getting into individual emails because really we're not litigating individual cases at this point. We're really still talking about you as a mass group of people rather than litigating your individual cases. Already talked about Go. Yes, Mr. Mehta is the judge. It's a good for us that we have him as the judge. Where's Nancy? I don't even know what this is referring to. I think they're saying they don't even send you individual emails. Yes, it's if they're not responding to you at all, that's something we need to know, right? Because they are required to at least respond to you, and that would be something that I'd want to tell the U.S. attorney is they're not even getting a response to their emails. Somebody likes my fish. Thank you. This is my third fish. This is the only one that has survived more than a few days. Sushi here has been with me for, I don't know, several months now and is doing very well. Well fed, has grown definitely to the size of his tank. I may need to get a much larger tank for Mr. Sushi soon. After you file the Brazil case, will we receive an email confirming we're in? No, you will not. There are hundreds of you in all these cases, so we cannot individually communicate with you. If you got a confirmation email saying that you've paid, then you're in. So, and what we will do is after we file the case, we will send out a redacted complaint that only lists your name, not your address. As we've told you from the beginning, we will keep your stuff confidential, but we can't keep your name confidential in the initial complaint because it's a public facing document. It's available on Pacer. So your name is on there. So what we will do is we will send you a redacted copy of the complaint, redacting your address, but having your name, and you can use that to confirm that you're in the case, and also that to confirm with the consulates that you're now a part of a lawsuit. Did you decide between motions for PI or summary judgment? Do you think you'll be filing next week? Yes and yes. I'm guessing that the Go case will probably be a motion for a preliminary injunction and or in the alternative summary judgment. So that it gives the judge two different ways to go about this. The difference between an injunction and summary judgment is that in order to win the injunction, we have to show irreparable harm. To win summary judgment, you just have to win, right? So the preliminary injunction adds another hurdle that we have to prove in order to get it. So it's actually harder to get an injunction than to get summary judgment. But we do believe that there's harm in this case because, there's a deadline to file these. So we will be moving for both. If the judge finds that there's irreparable harm, then he would grant that or she would grant that while we're waiting for the rest of the case to be decided. Okay, apart from, we didn't have our case number when the lawsuit was filed. Yes, you just need to email the NVC and the consulate with your case number and ask that the case be transferred to post for processing because you're a Milligan plaintiff. The affidavit declaration, don't worry about it. We will need the declarations for the preliminary injunction, but if one individual declaration is not, as good as it could have been, we have hundreds of others declarations. So, you don't need to worry about your individual declarations at this point. We're going to submit all of them and the judge is going to be looking at the plaintiffs as a whole rather than individual cases. Michael, thank you. Juliet Stuffed, that's her name. Juliet Stuffed is the policy person at DOS who publicly said, oh yeah, just move one case to another. You should submit, that document is publicly available and you should quote it when you're asking for a case to be moved. Of course, no dice because, our position is that's never been possible. They don't do that. But it's important that their policy people at the highest levels are saying that it's possible, and it's good for us in a case when you get an evidence saying no, they won't move the case. That's good evidence for us. So, Michael, if you will forward us that email, forward it to me directly. You don't need to send it to anyone else, but forward it to me. We can use that for the lawsuit. I have a new blessing in my family. It must be my fish. I would assume that's sushi. Thank you. Govey Blinken, can you recommend timelines? It's moving fast. Next week, we'll file the injunction and or motion for summary judgment. Yes, I already said this. Please do. Please do try to move the case. That's considered movement, right? If Moscow moves it to another consulate, we like that. It's movement, it's progress. So absolutely do that. Any improvements in H4 EAD processing with the new USCIS director appointment?
Hopefully,
it's H1B, Zach, so you have to take
so
it.
Back to me. Anyways, yeah, so this is another kind of like a Trump era thing that happened. So before, I mean, really, if you look at the processing time, like the actual hands-on officer time that it takes to process an H4 and an H4 EAD, it's a matter of like maybe an hour at most. In 2017, the elimination of H4 EADs was put on the regulatory agenda. It never actually got onto the books, but it was something that was a priority for the Trump administration to try to get rid of. Hopefully now that we don't have this past administration trying to put up these hurdles, things will kind of speed up. The biggest thing that happened, even though it didn't actually get put on the books, is there's other administrative burdens were put on the processing time, such as biometrics requirements that weren't really necessary. So if that's eliminated, processing times will speed up.
Do you want to talk? I think Ayla filed a lawsuit with Wasden and Benayes on this issue as well, right?
Yep.
And what's that? What is that case called? Do you know? I can't remember. I don't remember the name of the case. But I think that case is being filed as a class action. So if there's success on that case, then we should see significant improvements in H4 processing. So watch out for that one.
And I mean, in any case, just the processing times as they are just not sustainable. And I mean, you can only lose so many mandamus cases before the policy changes. I mean, H4 EAD processing time now is over a year, I think, is what they have as published. And you're not actually even able to file for a renewal until 6 months before it expires. So the fact that there's this like automatic gap in your employment authorization, it's not sustainable. And it will go back down.
A couple of people have commented that they are doing what we asked. They're emailing both the MVC and the consulates. They keep getting the same response. We know that. We still want you to do it on a weekly basis, because those stubborn, ignorant boilerplate responses that all of you are getting when you email the consulate are Exhibit A that we use to go back to the government to say the consulate doesn't care about these people, right? They're not moving on the cases. So I know it's frustrating, believe me, but it's something that becomes valuable in terms of creating an evidentiary record. So continue to do it. John, if you don't know the consulates of the NVC and London embassies, what I would recommend is there's a bunch of Facebook groups specific to consulates. So there's like the K1 London group and the K1 China group. And if you reach out to any of these other plaintiffs that have cases stuck in London, they will give you that information for the NVC and the London embassy. I don't want to do that now because then everyone's going to ask me to do that. I don't have time to do that on this call. So just go to those Facebook pages. If you get enough London's K1s, yes, we would definitely consider doing a group London mandamus. Our rule is you have to have 100 plaintiffs to get to the level where it's worth filing a mass action. So that's been organized by the Facebook groups. So as soon as you get to sufficient number of plaintiffs, we absolutely would file an individual mandamus or a group mandamus against the consulate. Once the judge makes a decision, let's say in favor of the case, and he says we would be priority, would that be enough for the embassy? I don't think that's going to happen in Kinsley. I think what's going to happen in Kinsley is the judge is going to say you cannot create a blanket, or you cannot create a proclamation that basically says that the president has authority to shut down the consulates without utilizing Congress. I think that's what the judge is going to say, which would mean that the proclamations go away for all visa categories. But I don't think the judge is going to be looking and saying, okay, now that you've won, let's prioritize all these cases. That's up to the government. The reason the government would want to do that is because every case that they moots out the whole case, right? There would come a point where there's no more redressability. There's no injury any longer if there's no plaintiffs that have a case or controversy that's alive. Okay. Paris scheduling interviews. Yes, they are scheduling interviews. We've seen a few that have been self-reported by plaintiffs in the past few days. I don't know what rounds those are, but yes, Paris is scheduling. Jennifer, you want to talk about where we're filing Rio? You're on mute still. Sorry, go ahead.
Sorry, I'm like furiously typing to get this done. So it's going to be filed in DC. And sorry.
And we're relating it to Milligan, right? Are we going to file a notice of related cases, or probably not, because it's
probably
just
not. Yeah, I don't think we are.
Yeah. Okay.
And we're filing it today. That's what I've been sitting here furiously typing, so making edits.
So do you mean that now we who are in mass action are part of the Penn lawsuit? Yes, you are. If you signed up to be part of the Brazil mass action, you will be in Penn v. Blinken. That will be the name of your case. A good. They tried transfer from Rio to Chile and it was denied. So yes, please forward that to Jennifer. We won't put that in the complaint because we're not, the complaint doesn't talk about individual plaintiffs. But if we get to a point where we're talking about harms, that would be helpful for us. Are they doing anything besides emergency visas right now? Yes, they are, right? I mean, we do have evidence that they're actually processing K-1s. Is that correct, Jennifer?
They are, but it's very few.
Mm-hmm.
The last data we have was from February, and there were, I believe, 2 processed, and I think there's been like 9 the last year.
Yeah, and those 2, I'm guessing, were Milligan plaintiffs, round 1. So,
probably.
Okay. Can you email the NVC, ask for an interview now? Yes, you can. If you are stuck at the NVC, you need to email both NVC and Cairo and ask for an interview. Okay, sounds like PI is important. You consider not filing it for Go and just going for some. Is there any risk for filing PI? Yes, there is a risk. We saw that risk play out in the Gomez case, right? Because Judge Maida said, okay, with regard to DV cases, there's harm, but everybody else, even if I say that the consulate should issue a visa, you're conceding that 212F bars entry. So I can still say to the consulate, you should grant the visa, but there's no harm because your clients can still not enter and you've conceded that. So there's no irreparable harm, right? If you lose on irreparable harm, you lose the injunction. Even more importantly, if you lose on likelihood of success on the merits, it's the kiss of death, right? Unless things change, you're going to lose the case. So there's definitely a risk of filing a PI. You don't want to do that unless you have a very solid case and you absolutely need this interim relief, which we do in DV cases.
And it can also, speed up the case overall if you just jump straight to summary judgment.
Correct. All right. Let's see. I'm skipping over some of these questions because we've already answered them. Do I recommend that Kinsley K1s file individual mandamus? Not yet, because you're still in the Kinsley case, right? So I would say what you want to do is wait to see what happens with Kinsley. And if depending on what happens with Kinsley, because remember, we're moving quickly on Kinsley, we're moving for summary judgment next week, then you'd want to file an individual mandamus. And the reason I say not now is because I'm concerned about, I don't think it would be impossible. I think there are 2 different legal theories. Zach, tell me what you think. I think they are 2 different legal theories. I don't think you're precluded from being in 2 different lawsuits in this case. But I don't want you to make a move until we know what happens on Kinsley next week.
I would agree. And also, there's the chance that the government will try to move you out specifically. So your case could get moved just, by virtue of being a Kinsley plaintiff.
Correct. All right, let's see. Yes. We would easily get 100 plaintiffs for mandamus. Bring it on. Love it. We love doing these. We love watching people get what they've paid for. So you can get 100 plaintiffs. Bring it on. We'll do it. Any guess as to the judge assigned for the K1 Brazil case? No, because I think because we will file. I don't know whether we'll file a notice of related cases. It's a little bit tricky because if you think about the Milligan case, we were doing two things. We were challenging the proclamations, but we were also filing a mandamus, right? With regard to Brazil, you're not subject to the proclamation. So the meat of the Milligan case is not related to you. Only the mandamus case is. And frankly, mandamus cases are so fact specific that I think we'd have it'd be tough for us to prove that all the K1 Brazils are related. So I'm not sure whether we'll relate it or not. We'll have to see what happens. We'll see what judge we draw, and then we can decide whether we want to relate it to another case.
I mean, as an example, we did not relate the Cairo K1 case to Milligan.
Yeah, I misspoke about it. I said earlier we did, but we did not. You're right, because it's just mandamus. Here's somebody has already answered your question. Here's the information about NVC and London. So here's the emails that you were looking for, John. Told you, your plaintiffs will help you. Okay, let's see, anything else? What are the chances that a case will be transferred? I mean, here's what I will tell you. A lot of plaintiffs in Milligan have asked for their cases to be transferred. I'm only aware of 2 cases that were transferred. The first was a case that was transferred early on, round 1, from Lima to, I believe, Ecuador. Actually, there were 2 transfers. There was one that was transferred from Lima to Guayaquil and another transfer from Lima to Ecuador. And then there was another case transferred out of Slovakia to Poland, but the woman who was transferred to Poland had Polish nationality. So that was why that one was transferred. If you have nationality in another country, that's the first thing you should try, is to switch it to the country of nationality. That usually will work. Also, if you're resident in a third country, that usually will also work to get a case transferred if you're living in a third country. That is all of the questions. Oh, here's another one. This one says, my case got transferred to London to Vilnius, but again, she's a citizen, right? So if you have citizenship in a third country, it definitely will happen. Other than that, it's tougher. Any other questions or any final comments that anyone wants to say? Stick in there with us. I know, look, we're not in your situation. I go home to my wife every single day, so you have to know that we hear your frustration. We're not in your same situation. So I know how frustrated you are. All that we would ask is that you put your trust in us, know that we are doing our best job for you, all of us, every single day. And that our goal is to win every single one of your cases. So be patient with us and hang in there and stay tuned for next week. We'll be back next week at the same time, same place. Ryland will have his walls decorated, I promise, by then. And until then, see you next time.